You know when you think something just cannot get any worse, and then it does, and then it does again, and again, and again. Yeah, that's this video. Karen's in court for a whole bunch of stuff. She's got a mad history. She's clearly a little bit unhinged. She tries to tell the judge that she's not, and then she proves that that's not the case. That she is, in fact, as unhinged as a broken door. Anyway, let's get stuck straight in, shall we? You're definitely going to want to wait to the end of this one.
All right, Ms. Adams, could you have Mr. Post come in, please?
He was doing a
Okay. Huh?
he was doing a drug test on something.
Oh, okay, he might be busy right now. All right. So, Ms. Rice, why don't you come up and we'll take care of you. All right, this is in the matter of the people of the state of Michigan versus Stephanie Lynn Rice, file numbers 21-20664 FH and 22-20716 FH. I have Salvatore Malaro appearing on behalf of Ms. Rice, and I have Phoebe Meir appearing on behalf of the people. Darren Post is present, is our pretrial services coordinator who did administer another test today. So we are here on a couple things today. One thing we are here on is a sentencing on a contempt of court, as well as a pretrial conference on the underlying file. Ms. Rice is charged with aggravated stalking, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine. We were previously set for trial, and now we are again set for, we are set for trial for August 1 for a one-day trial at 9 a.m. So with regard to first the pre-trial today, Mr. Malaro, how would you like to proceed?
Your Honor, I think if I understood Ms. Meir correctly, do you want me to do it or you want to do it? Okay, Ms. Meir is going to tell you what we're going to do.
Yeah, so, well, maybe, I guess I'll have Mr. Malaro correct me if I'm wrong, but the people are in a bit of a, I guess, uncomfortable situation or bad situation in these cases. In preparation for the trial, I did meet with some of my witnesses, the victims in this case, and they are quite frankly just fed up with this at this point. And I, obviously I could make them come in and testify, but at this point, I don't think they really want anything to do with this. So it does put me in a difficult situation. So what I am asking of the court is a bit unconventional, but I think their exasperation with this case and with Ms. Rice does have to do with obviously the time delays, the fact that we've been set for trial before, I think even a year ago, and Ms. Rice has, on a number of occasions failed to appear. She now has these new drug screens. So I guess what I'm asking for the court, again, it's unconventional, but that I will dismiss these felony charges as well as the PPO violations and ask the court to sentence Ms. Rice to the maximum on the contempt of court. I think that would accurately reflect the delays in this case and the fact that I do have to dismiss because of the delays in this case that were mostly at Ms. Rice's cause, just her, again, not appearing, these positive tests. And that's what I would ask of the court. I don't know if she would plead guilty to those contempts or if the court would find her guilty.
She already pled guilty to
okay, perfect.
Sentencing
yeah. And Mr. Coast did advise me that the drug screen today was also positive.
Okay. Mr. Malaro, are you going to object to people dismissing the underlying file as well as PPO violations?
Judge, no objection to any of that. The only other issue is clarification. I did inform Ms. Meir that I would be arguing the issue of how much time.
On the contempt court?
That the court would give. Yes.
Okay. All right. So, very good. I will move to the issue of sentencing on the contempt court.
So basically, she's up on a load of charges: harassment, stalking, breach of ROs, all of that kind of stuff. And she keeps doing it over and over and over again. The judge sits there and rattles off all these different things. And a lot of them are just simply her not turning up to court. And that's where the contempt charge came from, which is what she's here for today.
Are there new charges from this alleged incident that occurred the other day?
So there are new charges pending in in district court that have already been filed. I think it's a trespass, but it might be just an assault.
I think it's an assault and battery, Your Honor.
And then Mr. Coase advised us of an incident yesterday that may also have new charges. Those will obviously be dealt with in district court separately.
Okay.
And I, again, don't want to dismiss these charges, but I think at this point, it's best to move forward and not make Ms. Rice's ex and son testify if it's not necessary.
All right, so, with regard to sentencing today on the contempt court, are you ready to proceed that, Mr. McLeod?
And Your Honor.
All right, do people have any position on sentencing before the court proceeds?
Just like I said, I do think the maximum on the contempt of court would accurately reflect the delays in this case. Time is often in favor of the accused, and it certainly has worked in Ms. Rice's favor in this case. But that being said, I think the maximum on the contempt is more than fair, given her number of positive tests, including today being positive. And given, I could go back and see how many times this was delayed based on her non-appearance, but I don't have that figure right in front of me on both cases. And as well, that's not even counting the district court where she had failed to appear and was arrested in district court before it was found over. So thank you.
Mr. Millar, anything you'd like to say on behalf of Ms. Rice?
I would, Judge. Judge, I have represented Ms. Rice, I think, almost since the time I started the public defender's office. So I'm very well acquainted with Ms. Rice and all of her legal troubles. That being said, Judge, none of this is an excuse for her behavior, but 3-4 years ago, well, first of all, and I think this court's also well acquainted with Ms. Rice as well. Whatever happened prior to that is certainly played a great deal on her emotion, how she handles things at an emotional level. And I think as we all know, when we let emotions take control of our decision-making process, we usually make bad decisions. And Ms. Rice is engaged in counseling and therapy and will probably need it for a very long time to help her get past that area where she lets her emotions take control of her decision-making process. That being said, there are times where she is she has some good attributes. One is she's a good mother. And I know that this court could argue and not actually argue, but state that how can you be a good mother if you're using drugs that you shouldn't be using? And there's no debate with that. But by all accounts, through her CPS case, which I handled, and through today, her primary focus for the last 3 years has been her children. She has 2. She is the primary caregiver. The fact that CPS has closed the file on her shows that she's committed to continuing to be a good mother.
That was quite a while ago.
About 10 months, maybe. I think it was December, October. But she has continued to make strides to getting housing, getting the services she needs. Guardian, the last time we were in on that case, had no issues with her as her parenting skills. Ms. Rice faces many challenges, Judge. She was in district court yesterday, and I was present for that hearing, and the judge, spoke to her. And one of the things that's apparent is Ms. Rice has so much burdening her. Children, these pending cases, which I think if we can get them, if these are finally resolved today, will be a great help in getting her past that. Remove those stressors that I think will help her life settle down somewhat. She can spend more time focusing on her children. I think she tends to put too much emphasis on things and uses that as a way to justify some of her behavior, such as not appearing in court, not attending certain things. And I certainly understand the state's point of view on this and their situation. But I think this is a good resolution. I think that the longer she's in jail, the more risk her children are. And so with all of that being said, Judge, and knowing Miss Rice and knowing that she actually has a case, she has to be in district court on this assault charge this morning yet. But I told her to come here first, and she did. I'd ask the court to use its wisdom and fashion the most appropriate and lenient sentence as to any jail time as it possibly can. That would be our request on Ms. Rice's behalf.
Ms. Rice, is there anything you'd like to say on your own behalf?
Yeah.
This is going to be good. And then it gets gooder and even gooder.
Okay, I need you to go stand at the podium for me.
3 years ago, when Eleanor was born at Toledo Children's Hospital, her meconium came back. Was methamphetamine in it. And I had not touched it. I had never touched it. And so they did a very extensive and intrusive test through ProMedica. Eleanor had zero withdrawal. Zero. They monitored her for 6 hours. She had zero withdrawals. Not one withdrawal did she have. None. Because I wasn't using that drug. But the drugs that I take through my Dr. Noble, and Dr. Noble told me and my case manager this in her office, they cause a false positive. When Memphis was born, his meconium came back with the same exact test results, but they didn't even go through what they went through. They didn't call CPS. CPS never got called because they knew that it was verbatim the same exact as Eleanor's. My kids will lose everything, and I have worked really hard to get where we're at. We will lose it all. When I went to jail this last time, I lost my daycare for my kids, which is why I had to bring them to court. I reapplied. I started all over. I started all over all of my stuff again. This thing downstairs that happened, I need to be able to fight that because it's a lie. I didn't put my hands on her. She put her hands on me and my kids.
All right, so ma'am, I don't want you to talk about any pending cases because everything you say can be used against you because this is a court record. All right, so don't talk about events that occurred on new cases. Say that for your parents.
I know that my kids will be in foster care if I go to jail. I don't have anybody to watch them. Their dad has not seen them in over 2 months. I've climbed out of my trenches. I've climbed out of them by myself. I've worked by myself with them in tow, and we need each other, and they need me, and I'm not using.
So that whole story was about as much use as the letter G in lasagna. I'm sure the judge will let her walk. And even if she doesn't, I'm sure this lady's going to have a perfectly reasonable response to that. Or maybe not.
Oh. Mr. Coast, you administered a test today to her, is that correct?
Yes, ma'am.
And did she test positive for anything?
Tested positive for the THC, amphetamines, and also methamphetamines.
Okay. Now we know she's on Adderall, but her levels were extremely high, so that would be more than, and it wouldn't cause a positive
Correct.
test.
And to her previous test was a swab that was actually sent to the lab. I did talk to the lab. They said the only thing that would make methamphetamine turn positive is methamphetamine. We'll do a false positive because of the Adderall.
True.
All right, so Ms. Rice, now I realize that you completed a CPS case, you had your children placed in your care, and the case was closed in October. But what I will tell you, what I've seen is you go downhill since then. I'm talking now, not you. So on April 17th of 2023, There was a motion affidavit and bench warrant because you failed to call in to pretrial services coordinator. They're imposed on a daily basis. There were no call-ins from 4/10/23 to today. It's date on April 17th. Let's see. I have a drug screen collected April 6/23 that shows a positive test for methamphetamine. So then, let's see, we'll go to the next one. On May 16th, May 16th of 2023, you failed to appear for warrant on May 16th of 2023. Issued a bench warrant. Let's see, this one was filed April 18th. Try to call in. Let's see. Appear. Bench warrant arraignment. I have a failure to appear for bench warrant arraignment on May 16, signed by me on May 16. I have pretrial release order. You have to comply with CMH recommendations and medications. And we've got multiple tests that were sent in on a swab showing your levels are dangerously high. So,
Which
no,
my
Ms.
doctor,
Rice, I'm talking. So, Ms. Rice, I have great concerns about your mental health, your physical health, and your just defiance from day one of the court's orders, and also a downhill spiral that I'm seeing in your behavior. Court's orders are in place, and while I have great sympathy for your trials and tribulations, I also feel that you have taken advantage of that to some extent, trying to manipulate the court. But based on just the overwhelming issues I've had for you, with you and your failure to comply with court orders, I think you got off very lucky today.
She actually did get off really, really lucky. Maybe her luck's going to continue, and as I said, the judge will probably let her walk straight out the door back to her normal life, and if not, she'll have a perfectly reasonable response. But I wouldn't put my house on it.
Because the charges are being dismissed, but I am going to sentence you to court or to jail for 93 days.
please don't do my kids with your foster care, please don't.
Well,
Please,
get
Judge,
credit for any time you've already served.
can you please
You're all
suspend
set.
it? Give me
Thank
a
you.
try, please,
No.
Judge, please, I'm begging you. I'm begging you, my kids are gonna be in foster care. I'm begging you. I'm begging you, don't touch me. Don't touch me. I can't do 93 deals. Can I pay? Just please, can I bond out? Can I pay?
You're
I can't do this, please.
gonna get credit.
Please. This is why I don't come.
You're gonna get
Let
credit.
me go, please.
No.
Please let me go. Okay, but I can't breathe. I can't breathe this way. I can't breathe. I can't breathe. I can't breathe. I need some water. I can't breathe. I can't breathe. Please, can I have some water? I can't breathe. No, I can't walk. I can't walk. No, I can't. I can't walk like this. I can't do it. I can't do it. I don't have to be like that. I can't do it. I can't breathe.
You're not reading this.
I'll take it off. But I've heard that for 4 years. My kids have been going to foster care 3 years. Every time we're in court, I hear that. Sorry.
Well, that seemed like a perfectly reasonable response to show a judge that you're absolutely definitely not crazy. It seems to me like maybe she didn't have enough coffee today, unlike me, who's having it from this lovely Irish Demon mug, which you can get down below. Completely shameful plug. Because this video is probably going to get demonetized, but that's okay, because this was a lot of fun. I've actually got a whole load of new Irish Demon merch that you can check out in the link down below as well. Now, cards on the table. This is all her own fault. She has nobody else to thank for this but herself. herself. However, as a human being who has compassion, I do feel sorry for her. Obviously, she's got problems. Obviously, she's finding it hard to cope, but she simply isn't putting her kids first. It's as simple as that. So she has nobody else to blame but herself. I really do hope she gets the help that she very obviously needs. Screaming and bawling like a scalded cat is not going to get you anywhere, except into the lockup a bit quicker. Anyway, lads and lassies, thank you so much for joining me today. I really hope you enjoyed the madness. We'll catch you in the next one. Sláinte.